The next case that is set for oral argument this morning is Susan Lloyd versus Justin Rogerson. Both parties here on that?
I'm Susan Lloyd.
Okay, come on up. And Attorney Corrigan, is it?
Yes, sir.
Okay, so both parties are here for argument. Each of you will have 15 minutes to present your arguments. The appellant, which is you, Ms. Lloyd, may reserve up to 5 minutes for rebuttal. If you would like to reserve time, you just let me know and I'll keep track and try to let you know as you approach.
I would definitely like to reserve time, yes.
Okay, well, you just let me know when you come on up, and I'll let you know when you get close to that point in your argument. Okay. The arguments are recorded, so we ask that you keep your voice up. Would you like to just stay at the table when you argue? I see you're in a...
If I can, that would be great.
Okay,
or
just keep...
come up there in the scooter.
Whichever you're more comfortable with.
I'll come up there if that's closer to the microphone.
All right, that's fine as well. You have a concern about that?
No, I just want to make sure we can see her as she gets closer.
I wasn't sure if I should come up now.
Yeah, come on up now,
Okay.
sure.
Oh, no. Still behind the podium.
Yeah, can you stay behind the podium so the cameras are sort of...
Sorry.
Sorry
Oh,
about
yeah,
that.
we can see.
No problem.
I
How's
was
that,
worried
kid?
we wouldn't be able to see you. We can see you fine.
Okay.
Okay, so we've read the briefs and we're ready to proceed. When you are, you've indicated you would like to reserve some time. How much time?
5 minutes.
5 minutes. I'll let you know when you get close to that. Go ahead, Ms. Lloyd.
Basically, I moved out to Ohio in 2013 to go to the Cleveland Clinic. I was living in an apartment in Cleveland Heights that was full of rodents, no heat, no water, stuff like that. I did pursue a case against them. I was awarded in Cuyahoga County $31,000. The case is now on appeal from the defendants and everything. I had the same attorney, Attorney Hall, representing me in that case. And then what happened, I began to search for another apartment. I needed smoke-free because I am on Social Security disability for severe heart problems and that are greatly aggravated by any type of cigarette smoke. So I found this place in Worcester. It was pretty much the only one after calling over 300 places that was smoke-free. I moved in middle of July of 2014. I was reassured by Redwood Living, and it was in the lease. Their lease even covered outdoor smoking. It said it had to be within a sufficient distance not to migrate into your apartment. The day I was pulling into my driveway, Mr. Rogerson was actually in my driveway smoking cigarettes. My nephew, Brandon, he is my witness to this case, he was there. I politely asked Mr. Rogerson not to smoke in front of me. He went on to an over 15-minute tirade rant towards me. I explained to him I have a heart issue, I cannot be around cigarette smoke. I ended up calling the police. There was a police report from that day because he was extremely belligerent towards me. The next day I went to the office and I told them I cannot be around the cigarette smoke. They said we're going to solve the problem right away. Well, Mr. Rogerson continued to smoke, and at the time I did not know his name, okay? I tried to get his name from the complex. They wouldn't tell me. I tried to move out. The complex would not let me move out, contrary to what they said. They would refuse to let me move out. In fact, I have emails from them that they sent to Attorney Hall telling him I'm not allowed to move out. So, long story short, I began to rent deposit with Wayne County Court because I wasn't allowed to move out. I slept many nights in my car. And it's just me and my 2 service dogs that are there. They're trained to detect when my sugar drops and when I pass out. I began to cough uncontrollably when I was inside of the apartment. I ended up going back to the Cleveland Clinic and had a pulmonary test. That doctor, Thomas Ulbrich, actually wrote a letter that Mr. Rogerson was the sole cause of me developing asthma. I had other letters from my other physicians. Redwood Living ended up settling with me in November of 2015, but they knew during that settlement that Mr. Rogerson was being pursued separately. They tried desperately to put him in that settlement. The final written agreement between the attorneys took over 2 months because they kept changing the wording, trying to get him in there. But we told them over and over again, no, we are pursuing him separately. They knew. He testified in November of 15 a whole bunch of malicious defamatory lies, none of which he has ever been able to produce any types of evidence for. When we asked for written discovery, the only thing he even presented was a videotape where I'm inside of my apartment and he's wiretapping me. I knew he was doing this because I have AT&T on tape telling me that he was wiretapping me. Because when I would use my phone inside of my apartment, it would crackle, it would hum, it would do all types of things. After he moved out, of course, that problem stopped. The only reason why he moved out is because I ended up, his lease was actually over in November of 2014. He stayed an additional 2 months. I ended up going to the prosecuting attorney and I told him, this man is threatening me. I would go up to the dumpster and he would follow me and all this different stuff. I would try to videotape him. He would yell and scream at me and call me all types of filthy, dirty names. So what would happen is I went to the prosecuting attorney. This is all in the evidence. It specifically tells me to videotape Mr. Rogerson. When he got that letter from the prosecuting attorney, then and only then did he move out. The more that he saw that I wasn't getting thrown out, the more he smoked. And the more he would bang on his walls, he was actually charged for damages to his walls, okay? Because of him banging on his walls for hours a day to upset me. I knew he was banging on something because I have videotape of it, but I thought he was just banging on like a metal table or something that upset me. I didn't know he was actually banging on the actual wall. Until, like I said, after he moved out, I talked to maintenance. It took them over 4 months to fix the damage in this man's apartment that he caused. I have the drywall guy on tape telling me that he has severe damage all through his drywalls, and I said that's because he would bang on the wall. That's when I found out he was actually banging on the wall. I have permanent damage now to my lungs. I have asthma. I'm on multiple inhalers every day now. That's when my respiratory issues started. I'm on home oxygen. My doctor's actually working on getting that portable oxygen for me. And it all started with him. And he knew, he even testified in court. Susan Lloyd told me in July that she was sensitive to cigarette smoke. But I'm going to smoke whenever I want to. And when I get home, if I feel like smoking, I'm going to. And he even admitted to smoking up to 15 minutes at a time. This is all in his own testimony. And if you follow his testimony from when he testified against me, he changes his story within the same sentence. Susan Lloyd threatened me. Oh, but she didn't threaten me. She was on the phone with a friend. How was that a threat? His story changes. He makes up these delusional lies, none of which were true. When he had an opportunity to actually present evidence showing that I was actually harassing the man, he didn't present a single thing. They never asked for any of our written discovery. And then the whole motion for summary judgment thing, this case was set for trial. It was supposed to go to trial in April. My lawyer, Brad, went up to a pre-trial. The judge asked my lawyer, what evidence do you have? He said, I have 3 separate Cleveland Clinic physicians to testify what this man has caused damage to my client. There was never any expert witness deadline. There was never any discovery cutoff deadline, like none of that. We gave our witness list to Mr. Rogerson and his attorney. Not one time did they ever try to even do a deposition of any of those witnesses. So then Judge Reese at that pre-trial, now this is as per Attorney Hall, I was not there, told Mr. Keneally, Sean Keneally, I believe was his attorney who was there, to file a motion for summary judgment. And then he was given until I believe March 7th. He didn't file it until March 9th. Never even asked for an extension. Filed it 2 days late, never even asked for an extension. And then my attorney was supposed to have I forget how much time, but it was like a month or something to file his response. Within 2 days, we get another thing saying, no, I'm cutting it off, you have to have it filed by then. Well, I was in my attorney's office until midnight, he filed it. And then what happened is, I was upset, because like I said, this case was supposed to go to trial. It was set for trial, our witnesses were all ready to go and everything. And then it was canceled, at that pre-trial. And then what happened is, I was upset by it, so I went online and I wrote one simple thing on this Wayne County social media group. Has anybody had any issues with Judge Reese? Okay? At 4:30 that night, my attorney calls me up and he said, Sue, did you write this? And I said, yes. I sent him a copy. He goes, well, I don't see where you wrote anything wrong. You didn't defame him. You didn't threaten him. All you did was ask if anybody else had issues. I said, yes. And a couple people wrote back, said they had issues too with him. And then the very next day at 7:30 in the morning, the case was dismissed and I was called frivolous. And it was all based on an ex parte communication, because what happened is Attorney Terrence Keneally sent what I wrote to Judge Weiss and laid it on his desk. Because that's how my attorney found out, because Attorney Keneally contacted Attorney Hall and said, your client wrote something about Judge Weiss online, and I just sent it to Judge Weiss. So, you know, the whole thing is ridiculous. It was dismissed based on a ex parte communication. I'm sure he never even read what Attorney Hall wrote. It's obvious that Mr. Rogerson harmed me. It's obvious I didn't do anything to Mr. Rogerson. He never even counterclaimed me for anything. I mean, he's being so harassed by me and threatened he can't even go to work because I might harm his kids, which is ridiculous. But yet, when he has a chance to counterclaim, he doesn't even counterclaim me. When he has a chance to present any type of evidence at all that I'm doing any of these things to him, nothing. Instead, he shows up to court wearing a U.S. Army uniform, telling malicious defamatory lies. To this day, doesn't have any evidence or any proof of anything, because none of it ever happened. The simple fact is, Mr. Rogerson moved into a smoke-free community. Mr. Rogerson knew that I had heart issues. From his own testimony, admitted to that. Mr. Rogerson smoked as many cigarettes as possible to cause me harm. And when Mr. Rogerson was not getting his way, and I was not getting thrown out, he decided to harm me even more. And that's the bottom line. That's exactly what happened with this case. And I have a right to live in a smoke-free community and not breathe in cigarette smoke. And like I said, the complex settled with me in November of 2015 for falsely advertising a smoke-free community.
Now you're at 4 minutes, 44 seconds.
Yeah, I'm done pretty much now.
Okay, you want to reserve that. Thank you then, Ms. Lloyd. We'll hear from counsel. 15 minutes.
Okay.
Good morning.
Morning.
Chris Corrigan, on behalf of Justin Rogerson, if it pleases the court. There's basically one issue in this case, and I think that's basically what's been briefed, is regarding the cigarette smoke, and whether the main issues are basically a simple negligence issue. Number one, is there a duty? Is there a breach of that duty? Or was there an injury stemming therefrom? And we cannot even get to the issue of duty, because as the law is in Ohio right now, there is not a duty. I can't comment on what has happened in all these other cases with Ms. Lloyd. I just can't do it because I don't know what happened in them. But as to this case, Mr. Rogerson does not have a duty to her under the law. She does talk in her brief regarding various issues as to duties that a landlord has to their tenant. But we're not discussing landlord-tenant issues here. We're talking about neighbors. And there's really not this may be a first case at the appellate level in the state of Ohio, as far as I can see. But when we look around the country, it's a unanimous issue. You know, smoking is not an ultra-hazardous matter. It's not something that people do.
Counsel, let me just interrupt, because I know we don't have a lot of time. Isn't this a little different, though, because of the fact that it was a non-smoking community and he had at least not to smoke? Didn't he have a duty there?
Well, and I don't believe that his lease has ever made a part of the record from my recollection.
But wasn't it a non-smoking?
It's my understanding that it is a non-smoking community. But at the same time, does that still create the duty to her? And I don't believe it does. It does create a duty between landlord and tenant again. But I think even when you look through the case laws that I have presented, I believe the Alaska and the Maryland case, you do have various cases where, yes, you'll claim non-smoking duties, or basically non-smoking communities, but that does not still create a duty between co-tenants, or I should say co-tenants, one tenant to a tenant in another unit. And we don't have that here. As I believe the Maryland appellate court basically said, if I've got the appellate court case right, the Maryland appellate court case is, if you're going to now start to tell my clients that they can't smoke in their own private units, now this court has been taking the step of basically outlawing smoking in private residence, because, you know, we can say, you know, if we're going to be in a situation of okay, the smoke is emanating from one place. This is, I mean, we're talking about cigarettes, we're not talking about some type of mass machine, you know, producing multiple smokes here. I mean, and the fact is, I think the evidence that still shows too is that he's going outside smoking. What is, you know, I mean, if we can, once again, I don't think we get past duty, but would we ever really get to causation in this issue? And I don't think that we do get to causation. She says in her argument that the one doctor said it was the sole cause. I didn't read that in the attachments, and once again, those attachments were not even properly attached pursuant to 56C. But even so, in reading the expert reports, they basically gave general statements that cigarette smoking is not good for conditions. Understood. But they were, you know, he's not smoking in a compacted area with her, you know, an enclosed area with her. He's outside smoking a single cigarette. She goes into a lot of other things that are off the record that I cannot testify to, and that, you know, to us is speculation. What is in the record, though, is basically we have is that he smoked outside of the units. I don't know of any time that the association, the apartment complex, actually ever came to him and said what he was doing was improper. So we don't, you know, I don't know what happens with their settlement, but I don't see anything in the record that establishes that what he did broke any of the rules of the apartment complex. So, you know, as you say, it is a non-smoking unit, but people still do go outside. Can you let your friends come over, and can they go out and have a cigarette out on the driveway, out on the sidewalk? You know, are they supposed to go into the woods across the street?
Are the rules in the record?
I don't believe they are. I've seen, I don't think they've ever put into the record. So we basically were just limiting this to us the simple issue. And just,
Do you know if the rules prevented smoking only in the units, or did it prevent smoking outside?
my recollection, once again, I have not reviewed the rules because they were not put into the record. But my recollection was, I think there was some comment that there was a you know, wanting to be so far away from a unit. But as I say, I don't have those rules in front of me, and I can't recall what the specific length was. And to be honest, and truthfully, if you were to have me testify right now, I can't even say that right now.
Did the court base its ruling on the finding that there was no duty owed?
Basically, yeah, and I think that they, you know, and obviously it does go to this issue of frivolous, because, yeah, there is no duty owed between, and there's no law to establish that. To say that somebody's smoking, I mean, right now, could we say somebody's smoking outside the street, outside here, is affecting us? I mean, that's a long stretch. I mean, it's almost a Paul's graph connotation of, you know, is it emanating through the walls, that type of stuff.
Well, did you request a finding of frivolous pursuant to statute? And did the court make a finding of frivolous pursuant to statute, or did it just use that terminology?
I think the judge, after reviewing all of the facts of this case, and yes, and having discussed this issue now, and admittedly, I was not in the final pretrial either. And we're getting secondhand because her recitation of what happened at final pretrial is very different from the recitation that I got regarding that final pretrial.
Was there anything about that final pretrial that was on the record or transcribed?
No.
Thank you.
Basically, though, it's my understanding from conversations with Sean Keneally was he specifically requested a motion for summary judgment because there had been some delays in getting discovery done. But at the final pretrial, he said that I specifically requested the filing of motion for summary judgment. And Judge Wiest, because I think we're about a year and a half at the trial, or a year and a half out, he didn't want to delay things. So there was kind of an expedited thing to get it done if they were going to do it, but he didn't want to get to the 2-year mark, obviously, on the trial issue. So, you know, so basically, I think unless there's more questions, I'm just going to basically...
I have a question, counsel. What was in their summary judgment? I know you said stuff wasn't authenticated properly. What actually was in the summary? We'll look at everything when we go through the record, but what was in the summary judgment reply?
The summary judgment basically did have our motion for summary judgment had the affidavit of our client.
I understand, I know
basically
that, right. Mhm.
There was literally two separate exhibit attachments to her response to the motion for summary judgment. You have copies of letters from the doctors, I recall. You have basically advertising from Redwood Living. And that was basically, that was the vast majority of the attachments to the brief in opposition was what Redwood Living basically advertised. And, number one, yes, that wasn't authenticated. But number two, okay, to us, that doesn't affect our case. That's Redwood Living, and that affects, her issue with Redwood Living.
Counsel, in either her reply or her deposition or whatever, did she contest that Mr. Rogerson obviously said in his affidavit that he did not smoke around her apartment, but she's indicating that he did. Was that evidence was there any evidence presented to that extent in her reply to summary judgment?
I don't think that there's any evidence put forward as to that specifically. As to her deposition summary, as to her deposition, I mean, I do recall that she does talk about smoking, but as to how close, I mean, I don't think that there's going to ever be put in that he was ever actually in her premises. And I believe, my understanding too is how this is set up. These are kind of somewhat of, not necessarily townhomes, but connected houses, yes. But I believe that the driveways are connected too, so it's him standing in the driveway. I don't, when you say, was it close to her unit, I can't answer that. I mean,
No, I understand. I'm just looking at whether she had indicated that his statements basically were not true, because he's indicating he was far enough away that the smoke wouldn't infiltrate.
Right, and my recollection is that she does not have anything that
Okay, I think this is the only other question I have. Did you object to the, or not you, but did the defendant object to the unauthenticated documents attached to the summary judgment reply?
Well, we didn't necessarily even have a chance because, as she mentioned, the motion for summary judgment we filed the motion for summary judgment, they did their response, and within 2 or 3 days, the judge had already ruled on the motion, so there wasn't, it was kind of, we've done that now in our appellate brief, but there wasn't any point in which we even had a chance to move to strike those attachments.
So would we assume then that the trial court considered everything that was before him on both sides?
I think you have to. I mean,
even whether it was authenticated or not?
Well, I mean, I think he reviewed all the properly authenticated evidence, and even if it's all there. I mean, I think we all know that you'll look through stuff and take it in, and I'm sure the judge did according to the Civil 56C. Obviously took in everything that was there, and as I say, even if you're looking at I don't even think you get to the issue of causation. But even if the judge was going to review the issue of causation, the letters that were attached did not comply with 56E. But even if you were going to get past those 2 hurdles, my reading of those letters did not give the language saying to a reasonable degree of medical certainty. And I don't know how these doctors could even have done that. I mean, how can they say that this individual smoking out there is causing this issue? Because the other thing in her deposition testimony is she does talk about other people in the complex smoked as well. So, you're trying to limit a whole bunch of factors as to her health condition. That this one individual smoking over there is the cause of all her health issues, and the doctors don't do it to a reasonable degree of medical certainty.
Well, how they could have done that would have been an issue for cross-examination at trial.
Sure.
The issue is whether the letters actually say what she purports they say.
Right, and my reading of those letters basically were all generalized. Smoking is not good for this condition. Well, yes, I mean, smoking's, you can also say drinking's, not good, but, to say that this, but it does not comport with, none of the doctor's letters comported with the expert language requirements. So with that, we would ask that you sustain the Court of Common Pleas of Wayne County and affirm the granting of summary judgment. Thank you.
Thank you. Ms. Lloyd, you have 4 minutes and 43 seconds left for rebuttal.
Okay, well, one of the things he brings up is about duty. For one thing, everybody in Ohio has a duty not to harm anybody else, okay? I have a duty not to harm you, I have a duty not to harm you, not to harm you or anybody else in this room. It all goes down to negligence, and when an individual fails to exercise the degree of care expected of someone in that situation, and it results in injury, then it's negligence, and they are liable for any injury. Mr. Rogerson, again, he knew that this was a smoke-free community. He signed a smoke-free lease, and he smoked cigarettes up to 15 minutes at a time, as per his own testimony, okay? So that's one of the things. And again, this is a smoke-free community, and what he's saying is not true. We had hundreds of pages of attachments. I produced a diary of all the times that the cigarette smoke was infiltrating my apartment, and Mr. Rogerson was the only one connected to me. Nobody else was connected to me in this complex. I was an N unit, and he was my direct neighbor. I have the builder on tape, which is attached to that, stating that the vents in the units are connected to each other. Okay, the lease is attached to that, which clearly covers outdoor smoking. He knew he was causing me harm. That's why we went after him. He specifically testified in a court of law. Susan Lloyd said, I have a heart problem. Susan Lloyd said she cannot be around cigarette smoke, but I smoked anyway. If I wanted to come home and smoke, I did, up to 15 minutes at a time. Even after he knew he was causing me harm, and he knew he was causing me harm from day one when I called the police on him. Smoking in a private residence, like he states, that's totally different than signing a smoke-free lease and smoking in a smoke-free apartment and directly outside. And as per the distance, Mr. Rogerson's apartment was less than 10 feet away from me. Okay, we can all agree that less than 10 feet away is way more than enough for cigarette smoke to migrate. And my doctors, if you read their letters, for one thing, like I said, there was no expert deadline. So we didn't even know that he was going to sit there and tell him to file this motion for summary judgment, okay? And again, they had the expert witness list in January. They had plenty of time to contact those physicians and set up their deposition. They failed to do that. So they could have called them in and asked these questions to them. They failed to do that. And how do they know that this was the sole cause of my asthma? I've seen these doctors for several years prior. I started to see them in like 2010. They knew I never had asthma. It was all in my records. They knew I never coughed like this. I went to them because moving into that apartment, I began to cough uncontrollably. I coughed so much, Mr. Rogerson called the police on me, saying that I am coughing to harass him and disturb his son. When I'm coughing, when he's giving me asthma. So again, he knew what he was doing, and it was all maliciously done. And the whole court ruled on that ex parte communication. It had nothing to do with the merits of the case. Judge Weiss got upset because I wrote something online about him, and he dismissed the case for that reason only. That's the only reason why. And like I said, in terms of duty, everybody here is Mr. Rogerson is saying that he can get drunk, run somebody over, and have absolutely no duty for any of the person's injuries. It's simply not the case. And the lease covered outdoor smoking. I mean, he's obviously negligent. He was a smoker, knew he was a smoker, and the minute we went after his medical records or his psychiatric records, immediately put a permanent seal on by Judge Weiss from his attorneys. Immediately, within days, they asked for a permanent seal on his records because he doesn't want to sit there and have us know his psychiatric history and why he committed perjury wearing his U.S. Army uniform in court. He doesn't want us to know his medical records, where I'm sure his doctors have informed him how bad cigarette smoking is. And not only now they know that third-hand smoke, which is the residue left on someone's clothes, is just as dangerous as breathing in your own cigarette. These studies are widely known, and he knew he was harming me. That's the whole thing. He knew from day one he was causing me injury. And he purposely, maliciously did whatever he could. And like I said, the diary of how many times his cigarette smoke was infiltrating my apartment is attached. The actual lease, not only the smoke-free ads from the community, but the actual lease, there's hundreds of pages of exhibits that my attorney attached to his brief in opposition. The vents are connected as per the builder. I mean, his lawyer, not this one, but Terrence Camille
Ms. Lloyd, I have to stop you because you are out of time at this point.
Okay,
So thank you very much for your argument, both of you. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of the decision once it's released to both of you. And the opinions are also posted on the Supreme Court of Ohio's website.
okay, thank you.
Again, thank you both for your arguments today.